Today's lecture concerns the first merits judgment of the African Court of Human and People's Rights. If you haven't already done so, please review the excerpt of that judgment in the Mtikila versus Tanzania case on the Coursera website, and then continue the lecture. Let's begin with an overview of the facts and procedural history of the case. The case concerns a provision of the Constitution of Tanzania that prohibits independent political candidates from running for office, for president, the parliament, or local government positions. In order to run for those offices, a candidate must belong to and be sponsored by a registered political party in Tanzania. The applicants in this case, Mr. Mtikila and also an NGO that is challenging this constitutional provision, bring suit in the courts of Tanzania arguing a violation of their rights, specifically the right to participate in government, which is protected in the African Charter. The courts of Tanzania reject that argument, and the applicants file a petition or complaint with the African Court. And they can do that because Tanzania has both ratified the optional protocol creating the African Court and filed the optional declaration recognizing the court's ability to receive complaints directly from individuals and NGOs. Once the case gets to the court, the government of Tanzania raises a jurisdictional objection, and that is, in effect, that the conduct complained of in this case occurred before Tanzania had ratified the protocol, and thus it was outside of the court's temporal jurisdiction. And the court responds to this argument with something that I think you'll be familiar with, a reference to the continuing violations doctrine, which is the same doctrine we saw invoked as an exception to temporal jurisdictional limits in the Moiwana Village case from the Inter-American human rights system. Having decided that it has jurisdiction in the case, the court then turns to the merits of the claim, and that in turn raises questions regarding Articles 13, 27, and 29 of the African Charter. Here you can see Article 13 of the Charter, and its guarantee to every citizen of the right to participate freely in the government of his or her country, either directly or through freely chosen representatives. The other provisions of the Charter are limitations and duties clauses. Article 27.2 indicates that the rights and freedoms protected in the Charter, including the right to participate in government, have to be exercised with due regard to the rights of others, collective security, and morality and the common interest. Article 29.4 indicates that individuals have duties to preserve and strengthen social and national solidarity, particularly when the latter is threatened. These provisions are cited by the government of Tanzania to justify a restriction on allowing individuals to run for office only if they are affiliated with and sponsored by a registered political party. Now, the African Court, in reviewing these arguments, decides that those provisions are not sufficient to justify the restriction on independent political candidates. And I'd invite you to think about the persuasiveness of the court's reasoning with respect to these three articles of the African Charter in finding a violation of the right to participate in government. And I'd say three things about the court's reasoning in this case. First, the court is quite careful in citing to case law, jurisprudence, and decisions from other international human rights bodies. You may have noticed that the African Court cites to decisions of the UN Human Rights Committee, decisions of the Inter-American Court of Human Rights, and the African Human Rights Commission. The court does that because those bodies have previously considered similar legal and factual issues, and it looks to them for guidance, although those decisions are not binding on the court, they are persuasive authority. So the court tries to integrate, in other words, its decision within the broader fabric of international human rights decisions. Second, the court is quite careful to say that restrictions have to be narrowly tailored to achieve a government's objective. Here, the court takes the view that the prohibition on independent political parties and independent candidates standing for office is overbroad. That is to say, it limits too severely the right to participate in government. And you may notice that the court distinguishes an Inter-American Court of Human Rights case involving Mexico, in which there were more narrow restrictions designed to achieve social welfare and national unity. The third thing that I think the court does that's noteworthy is it doesn't question the need for Tanzania to have this prohibition on independent candidates at the early stages of its transition to democracy in the early 1990s. At that time, having some national unity rules that would restrict candidates to those who are part of registered political parties might have been necessary and might have been proportionate to the need to preserve national and social unity. But some decades on after independence, that kind of prohibition is no longer necessary, according to the court, because restrictions have to be narrowly applied so that rights can be as freely exercised as possible. I'd like to conclude our discussion of the Mtikila case by looking at some of the remedies that the African court awards. It declares violations. The issue of damages is not yet ready for decision, so the court reserves that, and it will come back to it in a subsequent ruling. And most importantly, the court orders Tanzania to take whatever measures are necessary to remedy the violations and to inform the court of what those measures are. That's an important and bold step for an international human rights court to take, but I do think it's worth noting that the court may experience some resistance from Tanzania in asking it to change or modify the national constitutional structure that currently is in place. I'll leave you with some additional sources about the Mtikila case and its significance for the African human rights system.